If you use ChatGPT to write your ebook, Midjourney to create your brand visuals, or just AI to script out your content, pause. Because here's the real question. Do you actually own it? In 2026, copyright law has made one thing very clear. AI-generated content doesn't work the way creators think it does. So before you go building your entire brand on AI tools, we need to talk about who owns the AI-generated content, whether you can copyright it, what happens if someone else copies it, and how to legally protect yourself moving forward. If you don't know me, my name is Brianna, and I'm a licensed Florida attorney with a concentration in business law, and today we're breaking down the 2026 AI copyright update. So let's get into it. Under current U.S. copyright law, including the 2026 guidance from the U.S. Copyright Office, purely AI-generated content is not eligible for copyright protection. Let me repeat that. If a machine creates the work and there's no meaningful human authorship, there's no copyright. Why? Because U.S. copyright law protects human creativity. Copyright Office has consistently ruled, including in high-profile cases like the rejection of AI-generated artwork submitted by Stephen Thaler, that works created solely by artificial intelligence do not qualify for copyright protection. No human author equals no copyright. That means fully AI-written blog posts, 100% AI-generated artwork, AI-composed music with no human modification, they may not be protected legally the way you think they are. And if it's not protected, you may not have exclusive rights. Now, I can already hear someone saying, Brianna, I wrote the prompt. Doesn't that count for something? And the short answer is not necessarily. The Copyright Office has established that simple prompts alone are not enough to establish authorship. You may ask why, and that's because typing luxury feminine brand logo in pastel purple tones into Midjourney does not make you the creator of the resulting image. It's the AI system that determines the expressive output. However, here's where it gets a little nuanced, and this is what separates the smart business owners from just the casual users. If you heavily edit the AI output, rewrite substantial portions, add original creative structure, combine a couple AI elements into a larger human created work, you may be able to claim copyright on the human created portions. The key word here is human contribution. The more you transform it, the stronger your position is. In 2026, the U.S. Copyright Office actually expanded their formal guidance as it relates to AI assisted works. They made three things clear. Number one, you must disclose when you use AI generated content when registering a copyright. Number two, only the human authored portions are eligible for protection. And number three, failure to disclose AI involvement can result in cancellation of your registration. Translation, if you file a copyright application for your ebook and you don't disclose that the entire thing was AI generated, you could lose your registration. And if your brand is built on digital products, courses, workbooks, or just creative assets, that matters a lot. Now, here's where it gets even more interesting, because if AI content isn't copyrightable, who owns it? The answer depends on the platform's terms of service, whether the output itself qualifies at all, or whether you modified it. Most major AI platforms say you can use the content commercially, but that doesn't automatically mean that you have enforceable copyright protection against others that copy it, which means someone can generate a similar output, slightly tweak it, and sell something very close to yours. And you may have limited legal remedies. This is the risk no one is talking about loud enough. If you're a course creator, an influencer, a digital product seller, or maybe just a coach using AI to create your materials, or a brand owner using AI for your visuals, here's one thing you need to understand. AI is the tool, not a shortcut to ownership. You can't outsource creativity entirely and expect legal protection. Here's a smarter approach in 2026. Use AI for brainstorming. Use AI for outlining. Use AI for drafts, but inject your expertise, your voice, and your structure. Make it unmistakably yours, because your originality is what creates legal protection. And if you're building your generational wealth off of ideas, you cannot afford weak IP foundations. So here's your action plan. Number one, keep documentation of your creative process. Number two, save drafts showing your edits. Number three, disclose any AI usage when filing a copyright application. And number four, don't solely rely on copyright. Use trademarks and contracts too. And let's be clear, your brand name, trademark that. Your course name, trademark that. Your logo, trademark that. Because trademark protection is not dependent on human authorship like copyright is. If you're serious about long-term protection, your legal strategy needs layers, not vibes. AI is powerful, it's efficient, it's here to stay. But ownership, protection, enforcement, those still require strategy. So before you build an entire empire on AI-generated content, make sure your legal foundation is solid, because I don't want to see you scale something that you don't fully own. If you found this video helpful, subscribe for more content on AI copyright law, influencer contracts, trademarks, and just protecting your business online in 2026. And I'll see you guys in the next video.